I am Ramona, and welcome to Ramona Interviews. And with me in the chair is David Baker. Now, David Baker is a researcher. He's a semi-retired entrepreneur. He is biographed in Who's Who in Industry and Finance, Who's Who in America, and Who's Who in the World. And we're welcoming him back again. Now, you may remember, if you've been following the series that we have with David here, the first one he did was the Federal Reserve Act. And then he came back and talked about hyperinflation. And today we're going to touch on the American jury, rights and responsibilities of the juror. And there's some surprising things, as there always is, when we wrap ourselves around what David is researching next. How are you, David?
Not bad, thank you.
Thank you for coming back.
Well, it's good to be here.
Thank you. Do you want to recap very quickly what the Federal Reserve piece was about and what hyperinflation was about?
I should say something about the one on hyperinflation because I referred to the collapse of the German pound. And of course, Germany never used pounds, they use the mark. And so I have to apologize for, apparently my tongue got in front of my eye tooth and I couldn't see what I was saying.
Well, thank you for clarifying that very much. Let's get into it. The American jury, what brought you into studying this? I mean, obviously you study constitutional law, and there's a lot to be said about that, and I'm sure a lot more, but you wanted to focus today on the American jury rights and responsibilities. What's happening in your research? What are you finding?
Well, actually, what I found is another title that we could use for the subject would be the fourth branch of government. Because we're taught in school that there are three branches of government. You have the legislative that makes the laws, the judicial that adjudicates matters of law, and then the executive that enforces the law. But there's actually a fourth branch that we're not told about. And that's we the people when we sit on a jury. An individual juror has more power in a criminal case than the President of the United States, the Attorney General, all the senators and congressmen and governors combined, because only a grand jury can indict a person. They wouldn't even have to stand trial if a jury decided to come up with what they call no bill of indictment. And even if a jury does indict, because they say a federal prosecutor can indict a ham sandwich. So
what does that mean?
Well, that means that the prosecutors go into the grand jury, which 100 years ago, they probably would have been thrown in jail for doing that because they're influencing them.
Okay.
But they can go in there and tell them whatever they want and mislead them and get an indictment. Now, even if they perjure themselves, have you ever heard of a prosecutor being charged with perjury?
No.
No, I haven't either. So, I mean, there's no consequence. So, but even if a person is indicted and has to stand trial, the juror on the petit jury, usually one of 12 people, has that same power. They can vote not guilty, even if the person did the act in front of 100 witnesses and it was videotaped.
Meaning that the jury,
the jury has the power to bring in a verdict in the teeth of the law. In other words, if a jury decides that a law is unconstitutional or that it shouldn't be applied in a certain case because of unusual circumstances, they have the right to vote their conscience.
And supersede the law.
And in spite of what the law says, and they cannot be punished for that, and they cannot be reversed. That not guilty cannot be reversed.
Is that written?
Oh
is
yes,
that
it's written in the Constitution, in the Bill of Rights, that no fact tried by a jury can otherwise be. I actually have it here someplace in my notes. It can't be reheard. In other words, it's final.
So if someone has a trial and the jury makes a decision,
Yeah.
I don't understand, because they always go back to trial again sometimes.
Well, they have what they refer to as a hung jury. And in most states, juries consist of 12 citizens. And they're supposed to be the person's peers. That was someone from their community.
Right.
That would know them. But
No.
today, if
What do you mean that would know
that would
them?
know. Well, that's this man, I know him, he runs the grocery store.
You mean that's the way they used to do it, or
That's
that's
the way
the way
it
they
used
do
to
it
be,
now?
yeah.
Used to be done.
Yeah, so
Okay,
you
used
would
to be.
know pretty much a person's character. However, today, if you were in the Vodaya process where they select a jury, and someone knew a juror, was a neighbor, for instance, they probably would be eliminated from being on
Oh
the
yeah,
jury.
you cannot know any of the arresting officers. You cannot
That's
know.
right, yeah.
They eliminate you immediately. I mean, I
Yes,
remember
yeah.
going to jury duty, and they
Yeah.
would ask, "Do
Yeah.
you know the
Right.
person up
Yeah.
on the charge? Do you know any of the police officers?" And they list them off. Do you know this? Do you know that? Do you know this? Are you related? Do you? And then
Yes.
they would screen
Any member
you
of
out.
your family on the police force.
And they would just systematically
Sure.
screen you out. And I always thought that was because they were trying to eliminate a bias.
Well, obviously, if you had two neighbors that were at odds with each other and feuding, you probably wouldn't want that person on your jury if you,
Right.
you know. But the jury is supposed to be representative of to represent the community.
Right. Okay.
And use their judgment. And then once they reach a decision, in a criminal case, it has to be unanimous.
So everyone must
I
agree.
think in all but one state. I think Louisiana is different because
Okay.
their law is not based on English common law, it's based on French law.
So it has to be a unanimous vote, and
Yeah.
then once that vote
Yeah.
is given.
Not guilty is not guilty.
Now, can
If
it-
they say they can't reach a verdict,
In other words, it can't get everybody to agree.
yeah.
Cannot have a consensus.
you have where one juror, say, is holding out and won't go the way of the others. They will sometimes declare a mistrial and grant a new trial.
And then they have to get all new jury people all
Right,
over again
yeah.
until they get an affirmative.
Yes, yeah. And sometimes they do. Sometimes it ends there. But usually because government can afford to go back as many times and take a bite of the apple as they want because they're using taxpayers' money to do it. It's not coming out of their pocket.
That's true.
Yeah.
That's true. So you're saying that there is are you saying that you feel that the way that things have changed within the judicial system, that jurors do not exercise their full responsibilities as intended in the Bill of Rights or as intended in...
Well, 100 years ago and before that, see how I could phrase this. 100 years ago, judges would inform the jury that they had a right to bring in a verdict, and they could judge both the facts and the law. Then there was a case that where there was a lot of pressure had to do with corporations not wanting to be sued, and there was a lot of pressure put on the court. And the Supreme Court said that, well, everyone knows that they have that right, so the judge is not required to inform the jurors. And the judges took that to mean that they could tell them whatever they wanted, and they started telling them that they are only to judge the facts, and you must accept the law as I give it to you. In other words, a judge would say what the law is. And the jury
law-
can only judge the facts.
Okay, the jury judges the facts of the case
Yeah.
as they are presented
Yeah.
by
Yeah.
both attorneys.
Yeah, and then the judge will say what the law is. Well,
You mean what the
obviously,
precedents to whatever's happening?
well, he'll
is?
tell them what the law is.
Okay.
And however, he doesn't necessarily quote the law. He gives his interpretation of the law.
Okay.
So now, judges are not supposed to make laws. That's why we have separate branches of government. You know, the legislative is supposed to say what the law is.
Okay.
But things have been corrupted and they've changed. And I was just going to glance down at my notes here. the precedent for a case like this, where, for instance, say a man's son got cut with a chainsaw and he had an artery that was spurting blood, and he put him in his pickup truck and was rushing to the hospital, and on the way he was speeding.
Yep.
And a policeman pulled him over, and instead of just saying, follow me, and give him an escort to the hospital, he decides he's going to write a ticket. Now, obviously, if the guy wasn't endangering anybody else, and the highway was clear, it would be his interest to get his son there as quickly as possible.
Right.
So now, if he fought this, and you know, any matter that involves more than $20, you're entitled to a trial by jury.
Oh, okay.
It's in the Sixth Amendment of the Constitution. I'm trying to think which one. It's the sixth actually is a speedy trial. The seventh is no. I'm not sure which one it's in, but it's in the Bill of Rights. And so now the jury's hearing the case, and they see, well, I do the same thing. I'm not going to find this guy.
Yeah, the law says that he was speeding, so therefore he deserves a ticket. But the reality of the situation may be that, okay.
And
but
so
this might be an exception to overrule a law, is what you're saying.
Yeah. Okay. So the jury can decide not to apply the law in that case and vote not guilty.
Okay, yeah.
Or it might be a case with some kids get stopped and they find a very small amount of marijuana in their car. And some states, the penalty is very, very severe, even for a small amount. And people might say, gee, do we want to see this young person go to jail because of a mistake that harmed no other individual? And they might vote not guilty, even though the evidence would show otherwise.
Okay. And but then that would be the system working well.
Yes. And that precedent goes back to Magna Carta, but it was, the principle goes back to Magna Carta, but actually it was in 1670 with the trial of William Penn, who was a Quaker preacher. And he was, like all preachers, were forbidden from preaching anything other than the Church of England. That was the official state religion.
Okay.
And so Catholicism was out, Protestantism was out, and of course he was a Quaker, and Quakerism was out. And so he was padlocked out of his church. And he wanted to have a service anyway, so people gathered in the street in front of the church, and there were several hundred people, as I understand it, and he preached to them. He and another gentleman named William Meade. He was arrested, and there are various accounts of the trial. I like to use the most dramatic, that he was charged with treason. Others say that he was charged with disturbing the peace. He went to trial, and in the trial they entered and took their hats off, and then were ordered. One account says the bailiff ordered them to put their hats back on. One said it was the judge. And then they were held in contempt for having their hats on in the courtroom. And so they basically tried to throw the book at them.
Right, yeah.
And the jury went out to deliberate. The judge said, now go out and find him guilty. The judge actually told them to find him guilty. And so they went into a jury room. There was actually two accounts. One was in the basement of the Old Bailey in a holding cell, and the other was on the second floor. But whichever it was, they had to go out until they reached a proper verdict, meaning one that the judge approved of, without fire, meaning no heat, because back then they had fireplaces, no food, no water, and no bathroom facilities. And so it would behoove them to come up with a verdict before too much time had passed.
Right.
And the account that I've heard the most is that they had to use the corner of the room as a toilet, that their friends were putting food and water up to the window so they wouldn't starve to death. And when they did come out, their clothes was soiled and they didn't smell very good. And they said that he was guilty of preaching in Church Street, but not guilty of treason or some such thing. The accounts vary.
Yeah.
And the judge was furious and sent them back and told them to come back with a proper verdict. And they didn't want to see a man jailed or hanged or whatever they were going to do to him for preaching his beliefs.
Right.
So they came back with a not guilty. And the judge was not happy. He fined them, threw them in jail. It was a huge fine. They couldn't be released until the fine was paid.
Yeah.
However, a higher court released them. And William Pentecost went on to come to America, and where they could have more religious freedom. And Pennsylvania actually was named after him. He was the first governor of Pennsylvania.